Fixed case item 9, value PS 177 of 2023.
Hindu governed by Hindu law?
Yes.
Hindu adoption.
Hindu adoption and maintenance act.
Give me the foundational dates.
Yes.
Written submissions. Mr. Sinha, Mr. Mukesh, your batch matter is at the end. You are waiting for that?
I'm ready. In fact,
Counter affidavit has not been filed.
counter affidavit has not been filed. In these
So,
cases,
in all those cases, we have checked the records. Maybe that during the court proceedings or maybe in the chamber where the counter has not been filed, we will give a date.
but my only one small request, if a shorter date is given, because day before yesterday, the cabinet has approved for counselling, so fresh counselling for para teachers, and they are likely to come up with a notification, therefore,
It is fresh counselling for para teachers.
yes, because they
So
were
you
denied
want the same order in terms of the division bench judgment?
the division bench order and one order having passed by the coordinate bench. In all these cases, the issues are common. Here, we have been denied counseling, or in some cases, we have been invited for counseling but not offered appointment on the ground that these petitioners have obtained their intermediate or graduation or matriculation from
No,
Devgandhi
we have
Vidyapith.
also passed certain direction in division bench.
Yes.
There is another judgment. So we
Yes.
will just, you see, single judge's order may not be of much help because the entire counselling is going to take place pursuant to the orders passed by the Honorable Division Bench. Right? So whatever observations have been made by the Honorable Division
In the
Bench
light of that also.
in two judgments.
Yes, yes.
One is 203,
And one is 510.
1510. So we have already passed certain orders.
My lords, can
Where is the respondent in your case?
okay.
You please call the respondent. We will take up the matter. Right? You come at around 4 o'clock.
And one more request on the second half, because I was having the first case as item 1 under final disposal.
Second half when?
The,
Today.
uh,
Today is this is the first.
I think seriatim, Mr. Sinha is referring to seriatim because this is at serial 9.
We have already fixed matter at 2:15 as first case to be taken up.
then
First, we will take up this case, and then if you are, then you have to wait for some.
yes, yes. I'm here.
But so far as batch is concerned, we have actually I did not know that what is the exact subject. But as you say, if this is the subject, then this same order is required.
Serious.
You just call for the other side. You are there.
Same order is filed by coordinate bench also for fresh counseling, division opportunity of counseling also. I am also responding to one of the case laws.
You don't see the division bench orders.
Yes, they after lots of the coordinator has also given them opportunity for appearing in the counseling.
Actually, in the light of division bench order,
In the light of the division bench only.
203.
Yes, sir. So
And what about the subsequent division bench order?
Yes, my lord.
in the light of 203 only the order has been passed.
No,
There is another judgment division bench. You are not aware.
In light of not in light of 203.
So therefore, that has to be incorporated.
Yes, 510.
in the light of 203 the order has been
And
passed.
if you say that if you give concession that everybody is to be considered, I will record your concession.
And that is the
You
order.
concede?
That is the order. I will give the lordship. I will bring that order to which has been passed by the
You
coordinator.
don't understand. The opportunity has to be given by as per the directions of the Honorable Division Bench. Everybody as a matter of right is not going to get an opportunity.
If he has scored the more on the last selected candidate.
And let us clarify, it's a 5 days back, it's a coordinate bench has taken into consideration 510 also. I am coming with that.
We have also passed orders.
Yes, yes.
That order is also uploaded.
Yes.
So
I'm
we will
coming-
pass the order in the same terms.
Yes, I am coming with that order.
Yes.
The challenge is to the order of dismissal, which is dated 12/11 and /12/4/22, two dates are there, which is at annexure 40, page 162 to 167.
Annexure 14,
Yes,
page
162 to 167.
yes.
And then the departmental appeal was also there, which has been dismissed. That is annexure 16/1, page 188 to 190. And the inquiry report is also assigned. That is annexure 12/1.
You are challenging the inquiry report also.
Prayer has been made.
No, what kind of challenge it is?
Assigning the inquiry report that it is not proper, it is perverse, and there is no proper finding in respect of the charges.
No proper finding. So there has to be fresh inquiry then if you challenge the inquiry report.
That is, the petitioner has chosen to, it is up to the honorable court to find if the prayer is
It is also
sustainable or
for
not.
you also to choose. If you challenge the inquiry report and if it is held that the inquiry report is vitiated on one or the other ground, then there will be a de novo inquiry.
Because the reason was that on basis of
You
this.
see, we can decide the case on merits only if there are admitted facts on record. Otherwise, 226, how does it, what is the scope?
On the, I will proceed on the admitted facts or the issue of law.
Then what about the challenge to the inquiry report?
While challenging the dismissal order, whether it is in accordance with the provisions of the certified standing order or whether it is in consonance to the principles of service jurisprudence on that. That is one of the prayer. On the admitted facts, even if otherwise, I take the inquiry report which is against me, then also that inquiry report which is on record, that does not give any definite finding so far as the charges are concerned. That is the content.
If the inquiry report is not giving any definite findings so far as the charges are concerned, you have a benefit out of it or you challenge it?
No, it is a thing. Sometimes we do not challenge it, or sometimes it is said that it is not required to be challenged. But sometimes it comes that cases on basis of.
Is there any violation of natural justice in inquiry report?
That is a case, but I will not be harping much on that. That is a case of the petitioner while replying to the responding to the second so-called notice. It had there. But on that, I think I may not succeed on that. So on that, I will.
Who is this person with this kind of address? Who is this person who has just entered? Anyways, you give your foundational date. Your date of birth.
5/12/1969. Date of birth of the petitioner.
When did you attain the age of 18 years?
18 years she completed in the year 1977. 5/12/1977. Yes, 87. 87. 18 years, 1987. And
What is the date of adoption as per you?
the date of adoption, as per the petitioner, it is sometime when he did not attain the age of 15 years.
Sometime means?
Since no definite date of adoption is there on record.
Any year mentioned?
Year is also definitely not mentioned. It says that sometime when he was around 14 years. There is no definite date.
It has been mentioned in the registered deed that when you were 14 years of age it was done.
The language is not like that. Language is that he is around 14 years. But we cannot.
Around 14 years?
But it is not prefixed or suffixed with the word 14 years as on the date of execution or as on the date of performing the ceremonies, religious ceremonies. These things are not there. So whatever is there on record, only from that
No, I want to know from you, what is your case?
Our case is that he was adopted before attaining age of 15 years. That is our case. Throughout, that is our case in course of the departmental inquiry also. This petitioner made such statement during his examination in the inquiry proceedings.
What is the date of registration?
Is 25/1/1985.
What was your age on the date of registration?
It was 15 years and one month. 15 years, 1 month, and some days more. 15 years, 1 month plus.
Okay. 15 year, 1 month.
Yes.
Who were the signatories to the registered deed?
The signatories are the natural parent, the parents, the father, mother,
Both.
both. And then then Sri Rameshwar Singh, the employee who has taken him in adoption.
His wife?
No, his wife is not there. And then one more person is there, Chandrika Misra,
Witness.
the person who performed the religious ceremonies. And one more witness is there.
He was examined?
Agnet.
He was examined? No.
In departmental inquiry, no.
One agnate is there.
Yes. Of the same caste as mentioned, Swajati.
One person of same caste. How do you say agnate? One person of the same
They
caste.
refer it as Goti or something like that.
All right. When did your adoptive father took VRS?
October 1998, he opted for VRS, and 89 he was given VRS. 88, not 98. 88.
What is the date?
The date is
VRS given in 1989.
just October 88 he opted.
On the ground of medical unfitness.
Yes, on the ground of medical unfitness.
All right. He offered you as a son for
Yes.
appointment,
Adopted son.
adopted son. When did he file this offer?
The date of application is not clear.
In the year 1989 itself?
88 or 89, because the 88 itself. 88 itself.
And by this time you had attained the age of 18 years.
Yes.
What was the age in the year 1988, your age?
1988, it will be around 18 years and 10, 11 months. December he will complete 19 years,
Few months.
a few months.
When did you pass your 10th?
He passed his, that certificate is there on record, in the year 1985.
Last 10th. 12th, 1987.
87.
$1989 is what? Educational certificate of 1989 is what certificate?
89 certificate. BA. BA he passed in May 89. The session was June 87 to May 89.
You passed class 12th in 87
Ah.
and you did your graduation in 89.
An arts, Bachelor of
Okay.
Arts passed.
Earlier 2 years graduation.
2 years. That college living certificate original is there. BA passports. June 87 to May 89.
So at the time of appointment, you must have furnished these educational qualifications.
Yes, that is his case. He has.
And
sent-
subsequently in the year 1993, what other educational qualifications?
93 is that the date of the college living certificate, no other certificate. College living certificate of BA. It is perhaps a wrong notion, under a wrong notion they have mentioned. 93 there is no other certificate. This is the date of issuance of the college living certificate. 20 July 1993. This college living certificate issue.
Then, when did they issue you the show cause?
First, so
And what was the cause? What was it that triggered the issuance of show cause?
9/6/2016? It was said that certain complaint was made, and then this petitioner as well as 2 other persons were issued notices.
For the same reason.
For similar type of complaints,
Okay.
because petitioner has taken up.
Where is it show cause? 965.
That is annexure 4. Annexure 4 at page 57.
Okay.
This
Page 57.
57. The letter was issued to them to produce their original documents. This is first is one.
Can you read it?
Yes. मुख्य प्रबंधक सच आंसर सीसीएल रांची के द्वारा निर्गत पत्रांक संख्या दिनांक 31/5/16 के आधार पर आप लोगों को सूचित किया जाता है कि दिनांक 13/6/2016 को सुबह 10:30 बजे अपनी पहचान संबंधी सभी कागजात कर्मचारी को वितरित करने।
Then charge sheet.
The charge sheet is a.
Kindly read the charge sheet.
Yes. This is 1st February 2017. After Sri Rameswar Singh Security Guard Kalyani project, the Dhori area CCL was declared medically unfit. You as his adopted son applied and were appointed in the year 1989 in CCL as a typing trainee, category 1.
This is not correct because the name was proposed by the ex-employee only.
Yes. His service record also contains my name as adopted son.
No. There are two things that after he retired, you filed an application as adopted son. It is another thing to say that during his lifetime and during his service period, he applied for his this medical unfitness, and then he said that the adopted son may be given the employment. So what is it?
Here it is mentioned that I have applied. The language is like this. You as his
Yes.
adopted son applied.
Okay. Then continue.
Yes. And were appointed in the year 1989 in CCL as a typing trainee, category 1, under the provisions of clause 942 of National Coal Wage Agreement. On scrutiny of records, it is seen that the deed of your adoption as son by Sri Rameswar Singh was signed on 25/1/1985, and on this date you had already crossed the legal age 15 years for valid adoption, which make your adoption void as per clause 10 4 of the Adoption Act 1956. To the educational certificates obtained by you in 1987, 89 and 93 after the adoption bears the name of your biological father, Sri Ram Lakhan Singh. The available records establish that you cheated the company and managed to get employment in CCL through invalid and pseudo adoption deed. And hence thereafter the charges are there.
Okay. What is the date of this document?
1st February 2017. 1st/2nd. Signature is dated 2nd February and the
Annexure 5.
annexure 5 at page 15.
Then what happened? You participated.
And one thing is important, this charge sheet, one word is there on the scrutiny of the records. Means my adoption deed is there on record.
That's right.
So, and thereafter the charges are also there, that about clause 22, 26.22 and 26.41 of the certified standing order of CCL.
That's right.
And 22 refers to any willful and deliberate act which is subversive or discipline or which may be detrimental to the interest of the company.
That's right. Your show cause reply is Annexure 6,
Yes.
dated
This is dated 9/2/2017.
9/2/2017, Annexure 6, right?
Yes.
Done. Then you participated. Where
the,
is the inquiry report?
The inquiry report is annexure number 12/1, page
So in the
136.
meantime, there was a writ petition.
He filed one writ. Initially, there was an interim order. Thereafter,
No
the writ
problem.
was
Then
writ LPA. That is page 137.
page 130.
137 is the second show cause notice.
Where is the inquiry report?
Page 138. Just next page after the second.
138.
8. Marked as annexure 12/1. The findings are from page 141.
Only read.
I'm reading from page 141.
Inquiry report is annexure.
It is annexure 12/1. And
Annexure 12/1,
and dated 15/12/2021.
relevant at page 141. Yes, please read.
The finding of the inquiry officer. I have carefully gone through the proceedings of inquiry and the oral and documentary evidences adduced by both sides during inquiry. It is sufficiently proved through documentary evidences that Sri Suresh Kumar Singh was appointed in the year 1989 as adopted son of Sri Rameswar Singh, security guard, Kalyani Project, Dhori area CCL, who was declared medically unfit under the provisions of clause 942 of NCWA. It is further established that the deed of adoption was executed. Further established that the deed of adoption was executed on 25/1/1985, and accordingly, in view of the age recorded in service sheet of Sri Suresh Kumar Singh, and also accepted by him, that is 5/1/69, he had crossed the legal age of 15 years required for legal validity of adoption under section 10(4) of the Adoption Act 1956. That after adoption, the adoptee severs his relationship with his biological parents for all purposes. But there are evidences which indicate that the educational certificates of Sri Suresh Kumar Singh pertaining to year 1987, 1989 and 1993 after the adoption bears the name of his biological father, Sri Ram Lakhan Singh. That is, he continued to have relations with his original family. This implied that the deed of adoption was executed only for the purpose of grabbing the employment in place of Sri Rameswar Singh as his adoptive son and no more. This way, Sri Suresh Kumar Singh cheated the company and entered into employment in CCL through invalid and pseudo adoption deed. The inquiry was held in total 19 sittings, and Sri Suresh Kumar Singh fully participated in the inquiry through his co-worker and has availed all reasonable opportunity provided to him to defend the charge leveled against him. He has availed LTC benefits by declaring Sri Rameswar Singh as father and Srimati Devavrat Devi as mother, though he was son of Sri Ramlakhan Singh. As he had crossed the legal age limit as of the date of adoption, the adoption is invalid. Srimati Devavrat Devi is the wife of Sri Ramlakhan Singh and biological mother of Sri Suresh Kumar Singh, but she was declared as wife of Sri Rameswar Singh. Even in his educational qualification certificates, the father name is Sri Ramlakhan Singh and not Sri Rameswar Singh. Therefore, it is proved that Sri Suresh Kumar Singh falsely declared himself as adopted son of Sri Rameswar Singh solely for the purpose of managing the employment in CCL as dependent son of Sri Rameswar Singh, though at the same time he continued to maintain dual identity as son of Sri Ramlakhan Singh also. Sri Suresh Kumar Singh did not cross-examine MW1 when given an opportunity on 5 to 21. He was absent on 9 to 21, 15 to 21, 1 to 21, 9 to 21 and 24 to 21 on pretext of sickness and deliberately did not cross-examine MW1 despite his availability on all days. On 16/4/21, he did not cross-examine on pretext that his co-worker would examine MW1. On 27/4 and 31/5/2021, he was again absent due to lockdown. On 12 July 2021, he did not appear with his co-worker, and M1 also could not appear due to his head injury. Thus, from the above, it is inferred that the cross-examination of MW1 was deliberately evaded by Sri Suresh Kumar Singh, which indicates that he had no intention to cross MW1 and therefore the deposition of MW1 remains uncontroverted. Sri Rajiv Kumar Jaiswal, Assistant Manager Legal, produced as MW2, has been able to prove through documents that there are certain prescribed conditions for a valid adoption under Hindu law. As per Section 10 of Hindu Adoption Act 1956, no person shall be capable for be taken in adoption unless he or she has not completed the age of 15 years. The deed should be executed between the adoptive and biological parents and not the adoptive person. Hence, the adoption deed of Sri Suresh Kumar Singh is invalid under law as it violates Section 10 of the Act. He further proved that as per law after adoption, the adopted child shall be deemed to be the son of adoptive father or mother for all purposes from the date of adoption. And from such date, all ties of the adopted child with his family of birth shall be deemed to be severed and replaced by the adoptive family. And hence, the adoptive person cannot enter the names of his biological parents in any of the official documents like service sheet. Legally, Sri Suresh Kumar Singh could not prove any custom or usage applicable to him which permitted adoption beyond 15 years of age. Nothing material could be elicited through cross-examination of MW2. Any adoption made in contravention of provision of the Adoption Act is null and void ab initio, and none of the contentions of MW2 could also be controverted by the defence side. No witness is produced by defence side, though the charged employee submitted that the adoption deed at the time of his appointment was sent to CCL headquarters, including legal department, and he was offered employment on 3/5/1989. Only after acceptance of the adoption deed by headquarters legal department. No evidence has been adduced to support his contention, and hence the same is rejected. The employment file was not provided to him due to non-availability, but he was given all opportunity to defend his case, so there is neither violation of natural justice nor the non-availability has prejudiced his defense. The adoption deed is invalid as it is in violation of Section 10 of the Adoption Act 1956. No plausible reason has been explained for continuance of his original father's name in educational certificate even after so-called adoption. Sri Suresh Kumar Singh, despite instructions, did not subject himself to be cross-examined by EMR or one pretext or other and played delayed tactics. Accordingly, direction was passed to MR to submit the management brief. In his defense brief, the charge employee has not at all entered into the merits of the case to demolish the arguments of the management which remains uncontroverted. The contention that the inquiry has not been conducted fairly is not acceptable as all opportunity has been provided to Sri Suresh Kumar Singh to defend the charge. He had no intention to produce any witness, but only delay the process of inquiry. The employment file was also not available, as so could not be produced during inquiry. Further, there is no strength in the argument advanced that he was appointed under the signature of area GM, but the charge sheet had been issued by the project officer. No such preliminary issue was raised by him at the earliest opportunity, and such arguments cannot be taken at fag end of the process when he has voluntarily participated in the inquiry to defend his case through his cover. The circulars dated 1/10/99 and 25/3/23 regulates the power of competent authority to act as disciplinary authorities under standing orders and cannot be challenged. As such, there is no need to keep the proceedings on hold.
The date of application is on record. The application is on record.
No, it is not on record. It is not on record. It is not on record. And then it is on the circulars dated 1/10/99, 25 regulates the power of competent authority. As such, there is no need to keep the proceedings on hold merely because the same has been challenged. Sri Suresh Kumar Singh before any forum. That after carefully weighing the arguments raised from both sides in the written briefs, the balance of convenience tilts in favor of management. The undersigned is constrained to conclude that the charge level Sri Suresh Kumar Singh is fully established.
That's right. Where is the order of
After that is
dismissal?
we replied. That is at page number 162. Next step 14 at page 162. The first page narrates the facts.
Come to the findings treated.
Yes, the findings are there from page 163 middle portion, referring to his petitioner's reply to second super's notice.
Just a minute. Page number?
163, the second page of the order.
Okay.
In the middle, first, second, third, fourth, fifth, sixth para. And whereas Sri Suresh Kumar Singh submitted his representation,
Okay.
the said representation has been carefully perused. The arguments raised by Sri Suresh Kumar Singh and the reasons why such arguments are not tenable is mentioned against each argument. Sri Suresh Kumar Singh has raised query as to whether the validity of the adoption deed can be questioned in departmental proceeding after completion of 29 years of service. This argument is not tenable and no period of limitation is prescribed in law under which there is any bar in initiation of departmental proceedings against an employee on detection of any irregularity committed by him in connection with employment.
That's right. Next.
Then the
Regarding
second
contention.
contention of that Sri Suresh Kumar Singh voluntarily participated in the demand proceeding and further circulars of nomination authorities cannot be challenged. Sri Suresh Kumar Singh argument is conceived.
This is hardly anything.
Yes. In,
This we can omit. Right?
yes.
Next.
Then the third one is about, again it may be relevant. Third one is relevant. The inquiry officer failed to take into consideration that validity of the adoption deed could only be challenged by filing a civil suit under the law. The departmental authority lacks jurisdiction and authority to exercise scrutiny of a registered adoption deed. Departmental delinquent employee had produced certified copies of the page number 468, 469 and 470 of the registered procured from Office of Registrar Aurangabad. The mere fact that the adoption deed is registered does not raise any presumption that the deed of adoption is valid in law. Any deed which is in violation of Hindu Adoption and Maintenance Act cannot be rendered valid only on the account of same being a registered document. Sri Suresh Kumar Singh had crossed the legal age of adoption on the date of adoption. Hence, as per the said act, the same cannot be treated to be legal and valid as per law. So here there is an admission that the registered deed was there and there is no dispute with regard to the registration of the deed. This finding is contrary to the law so far as presumption is concerned. Then the next submission of the petition, next it is also relevant. Sri Suresh Kumar Singh submitted that it is nowhere the findings of the inquiry officer on the date when giving in and taking of adoption ceremony in fact had taken place, he had crossed the permissible age of 15 years for a valid adoption. Sri Suresh Kumar Singh further mentioned that in the departmental proceeding dated 6/9/2021, at page number 3 of his adoption deed, it was mentioned that his adoption had taken place following the rituals and at the age about 14 years. Further, in paragraph 5, page number 3 of the adoption deed, it was mentioned that the adoption shall be effective on and from the date adoption follows by religious rituals in fact was taken place. Inquiry officer has not taken this fact into consideration nor has assigned any reason to discard the same. The submission is not acceptable. The inquiry officer in his finding has categorically observed that the date of birth 5/12/69 as recorded in service sheet of Sri Suresh Kumar Singh has been admitted by him as correct date of birth. The adoption deed executed on 25/1/85 when Sri Suresh Kumar Singh had crossed the legal age of 15 years for valid adoption. Hence, the argument of Sri Suresh Kumar Singh that at page number 3 of his adoption deed it is mentioned that adoption has taken place following religious rituals and at the age about 14 years is not reasonable. Any adoption takes place from the date of execution of the adoption deed as it is claimed to have been laid down in paragraph 5 of page number 3 of the adoption deed. It is therefore documentarily proved that as on the date of adoption, Sri Suresh Kumar Singh had crossed the legal age, thereby rendering the adoption deed invalid in the eyes of law. He has not been able to prove any ritual customs and usages to prove that adoption beyond the legal age was permissible in his family from time immemorial. Then the next one is with regard to the appointment file. The charge cannot be affirmed without bringing on record the appointment file. These vital documents was not produced in the proceeding. Thus, there was denial of reasonable opportunity of defense. The appointment file could not be placed during the inquiry as the same had been missing. This itself creates reasonable doubt to a prudent mind which leads to irresistible inference that the file was misplaced too capriciously to conceal the irregularity.
Where is it?
The very last paragraph, page 164, after about the validity of Roman 5. The appointment file could not be placed during inquiry as the same had been missing. This itself creates...
Any FIR lodged?
No. Neither any FIR lodged nor any proceeding initiated against any employee of the company. And then therefore his argument that charges cannot be affirmed without bringing a record appointment file is not plausible. The adoption deed based on which appointment... Now they also say the adoption deed based on which appointment was offered in the year 1989 is a vital document produced in the proceeding to support the management case. These last but 3 lines are also very relevant. They admit that the adoption deed is the basis of appointment. It was before them. Is vital document produced in the proceeding to support the management case. Thus, there is no case of denial of natural justice made out. Then, next page 165. The cross examination has been denied, which we said the entire proceeding after some argument, after some adjournments of date, proceeding finally held on. Denied the opportunity of cross examination.
Okay, that's it.
Yes.
Then you filed an appeal and appeal also dismissed
Yes.
in the similar manner. What is your point now?
Now, the charge sheet, if I am allowed to just refer
So
to
we have read it full text,
Huh.
right? You just tell us, you just formulate your point and you argue.
Yes. The first point is that the charge is that I have committed misconduct as I have cheated the company and managed to get employment in the company by an invalid and pseudo adoption deed. That is the basic charge. That I have committed misconduct within the meaning of the company's certified standing order and getting employment by getting employment through invalid and pseudo adoption deed. Now this charge, invalid and pseudo adoption deed, on this there are twofold points. One is that this is a registered deed, as the proceeding shows, the inquiry proceedings as well as the disciplinary authorities order, that they have not disputed the registration of the deed. That deed is a registered deed. Now, when there is a registered deed under law, in terms of section 16 of the Hindu Adoption and Maintenance Act, law prescribes a presumption in favor of a registered adoption deed, and it is a rebuttable presumption, and that can be rebutted only in course of a properly framed shoot. That rebuttal cannot be in a departmental inquiry. That presumption can be displaced.
Act का legal adoption and maintenance ये बना दिया.
जी.
Read that section, please.
Yes, section 16. Presumption as to registered documents relating to adoption. Wherever any document registered under law for the timing in force is produced before any court purporting to record an adoption made and is signed by the person giving and person taking the child in adoption, the court shall presume that an adoption has been made in compliance with the provisions of this act unless and until it is disproved.
That's right.
And it is shall presume, and unless and until it is disproved. So, first thing is that as the inquiry officer.
That's right. What else?
Yes. And the second point is that even
How has the inquiry officer, how has the disciplinary authority dealt with section 16? Because you have raised your plea with regard to section 16. Is there any discussion?
Yes,
with
that
regard to
discussion
section
is there, which is I will just once more refer to. The discussion is without considering the provision of law, page 164.
Yes.
Page 164, the second paragraph.
The mere fact that the adoption deed is registered does not raise any presumption. So this is contrary to section 16?
Yes.
And hence perverse.
Yes.
This is first point?
Yes, this is contrary to law.
Alright. How has this point been dealt with the appellate authority?
The appellate authority has also dealt with in similar line. The appellate order, page 188. Page 188. The last page, page 190. Page 90, there is a reference to this adoption deed. First, in the legal opinion, it has been clearly opined that deed of adoption of appellant worker does not create any valid adoption. Does not create any valid adoption. Firstly, for the reason that Sri Suresh Kumar Singh could not have been taken adoption on 25/185, as by that time you have already crossed the age of 15 years. And secondly, as per your own saying, even after several years, you continued declaring your biological father as your father-in-law documents and everything.
That's
So there is no consideration of this fact. And another point would be that even otherwise, this deed was as a specific finding has been recorded in the disciplinary authority's order. This deed was the basis of his appointment. So company was aware of the facts about execution of the deed, on basis of which the petitioner made out a case that he is the adopted son. And upon examination of that deed, they have offered an appointment. It is not a case that there is any suppression or any misrepresentation on part of the petitioner. And so the charges that he managed to get employment in CCL through invalid and pseudo adoption deed is not at all proved.
How do you explain your subsequent education qualifications?
Subsequent, since once it crept in the matriculation certificate, so accordingly it was entered
Your
in the
matriculation was
the form was filled up in when I was not adopted. That is my specific reply to the charge sheet also, and also in reply to the inquiry report. The form was filled up when I was not adopted, and so I filled up my biological father's name, and subsequently it continued in the same manner. It continues. That is my explanation to that, which I have given in course of inquiry also. And now it is not a case of fraud. It is not a case of fraud because it is not
you have
that.
attained the age of superannuation.
No, it will be in 29. 60 years he will attain in 1929.
How long have you been out of service?
32 years as on the date of dismissal.
Okay.
80
32 years you have already served.
Yes, 89 to 22. 22 was dismissed. That is more than 32 years.
That's it.
More than.
Respondent?
So three things. First, I will show from the deed itself that the deed was executed and the intention to enter into the service on the basis of it will be apparent from the perusal of the deed itself. Lordship will kindly come to
What is your case? According to you,
case
what
is-
is the date of adoption?
the date of adoption is date of the deed. It is apparent, your lordships. Lordship, page 47.
Read the
I'm
entire
reading.
deed. It's a two-page document.
I'm reading it from the typed copy given served by the petitioner. यह कि मन मौकिंग की स्त्री का स्वर्गवास
Annexure number?
That is annexure 1, page
page 46 it starts.
Yes, kindly read it.
Yes. Also, first page is Rameshwar Singh Wald Ramkishan Singh Sargwas कॉम ब्राह्मण सच एंड सच कस्तकारी व नौकरी पर नाम मुखिर का श्री सुरेश कुमार सिंह पेशा नाबालिग श्री
Rameshwar Singh and Suresh Kumar Singh, they are from different family.
No, Rameshwar Singh is the employee who is my adopted father.
Okay.
He was.
And Suresh Kumar Singh?
Suresh Kumar Singh is the petitioner before you. This
Oh,
article.
Suresh Kumar Singh is the petitioner.
Petitioner. And Rameshwar Singh is
Okay.
the person who has taken me in adoption.
All right. Okay, fine.
श्री सुरेश कुमार सिंह पेशा नाबालिग श्री रामलखन सिंह व लयत गार जीपन श्री रामलखन सिंह पिता कायम
Ram Lakhan Singh is the full brother
Biological-
of Rameshwar
Biological
Singh.
father, yes.
Okay.
पिता कौम ब्राह्मण भूमिया निवासी ग्राम जैतपुर थाना सचन सच अंचाहा जिला औरंगाबाद पेशा कस्तकारी कसीम विकास गोदनामा। नेक्स्ट पेज यह कि मन मुकिन के स्त्री का स्वर्गवास कर गई है, वो उम्र करीब 48 वर्ष का हो रहा है। वो आज तक अपना तन से कोई औलाद पोता या परपोता नहीं है और वो ना ही आइंदा कोई उम्मीद है। हालांकि किसी प्रकार की बीमारी मानसिक या शारीरिक नहीं है, किंतु अपना आइंदा जीवन के अकवाद को बनाने के बारे में हमेशा सोचा करते हैं और आइंदा धार्मिक संस्कार एवं आत्मा के शांति बनाने वास्ते पिंड दान के बारे में अपने निजी पुत्र का होना जरूरी है। इस बात को अपना सहोदर भाई राम लखन सिंह एवं उनके पत्नी अपनी भौजाई से सलाह किया और अपना बड़ा लड़का यानी मोखिर अल्ले को मुझे गोद में रूप में दे दीजिए तो हमारा भी अकवाद बन जाए। इस बात पे दोनों माता पिता एवं पिता मोखिर अल्ले काबुल वो मंजूर किए। यह कि मान मुकिर हालत सेहत जात वो सवाल अकल बदरुस्वे हवास बोला डराने और धमकाने या फुसलाने वादने दावा नाजायज किसी गैर के अपना नफ़ा और नुकसान के बेखूबी समझ बूझकर खुशी और राजी से मिलकर अल्लाह को गोद लिया। वो अपना पुत्र बनाया और गोद लिखने को आए। यह कि मुकिर अल्लाह का अलावे और किसी दूसरे लड़के को आज तक गोद नहीं लिया। यह कि मुकिर अल्लाह हमसा मन शाकिर के फरमा वरदारी के सेवा टहल में लगे रहते हैं एवं उम्मीद है कि वह आइंदा भी इसी तरह से सेवा अटल तथा मरने के बाद दाह संस्कार श्राद्ध एवं पिंड दान भी कर देंगे एवं अधिकारी होंगे। चुके बिना इस कार्य हेतु हिंदू शास्त्र के मुताबिक आत्मा की शांति नहीं मिलती। यह सोच विचार कर धार्मिक संस्कार के रूप में गोद के कार्य पहले ही हो चुका है। इसमें किसी प्रकार का नहीं है, चूँकि इस बात का बहुत लोग को जानकारी है। यह कि मुकिर अल्लाह का उम्र 14 साल का है, किंतु लॉर्डशिप कैन मार्क दिस, यह कि ही इज टॉकिंग अबाउट प्रेजेंस। यह कि मुकिर अल्लाह का उम्र 14 साल का है, किंतु अभी तक अविवाहित है, बिना जागो पौती का हूँ और मैं मुकिर अल्लाह के माता पिता से ने धार्मिक संस्कार द्वारा अपनी राजी खुशी से अपने लड़के को गोद में दिए। वो इस कार्य के बिल्कुल के काबुल मंजूरी किए। आवाज रहे कि मोकिल वाले के पिता आपस में सहोदर भाई हैं और एक ही जाति के हैं, एक दूसरे को गोद नहीं लिया जा रहा है। यह गोदनामा का असर धार्मिक संस्कार द्वारा गोद लेने के दिन से ही है। यह कि अब गोद संस्कार धार्मिक रूप से संपन्न हो जाने के बाद मोकिल वाले मान मोकिल का खास लड़का हो चुका है, उसका कुल संपत्ति अचल जो हासिल है वो आइंदा हासिल होगा। कुल संपत्ति वजीन साहू पिता के मोकिल अल्ले का को हुआ तथा उसके मरने के बाद पुत्र का अधिकार हासिल हुआ हो रहेगा। जो बाद में मरने के मनोकरीम उनका दाह संस्कार श्राद्ध और पिंडदान के अधिकारी मोकिल अल्ले के हुआ, जो सब मन को
It is referring to past transaction.
But kindly see the sentence over here. यह कि मोकिल वाले का उम्र 14 साल का है।
Incorrect. As per his class 10 date of birth. But the deeds is referring to past transaction.
काज पहले
He
ही हो
says
चुका है।
no date is mentioned.
यह
And
कि
there-
गोदनामा का असर धार्मिक संस्कार के द्वारा गोद लेने के दिन से ही है।
तो गोद
So
लेने के
just-
दिन कितना दिन पहले हुआ क्या हुआ, there is no mention.
तो आप क्या कर रहे थे जब अपॉइंटमेंट दे रहे थे तो? What were
I'm
you
coming
doing?
to- I'm coming further, your lordships.
I read it. आके नौकरी का बात भी बोल रहा है, यही
हाँ, आगे
ना?
नौकरी का बात भी बोला। This is
Naturally,
one.
he
Now
will be
your
entitled
lordships-
for everything.
Yes.
Did
Now
he
your
disclose in your records that he has adopted a child? He did.
Yeah, yes.
He did. He mentioned and thereafter he applied
Right.
for superannuation.
He mentioned, he disclosed that he has an adopted son. He applied for superannuation on medical grounds, and as per scheme of NCWA, he was given the
Given
appointment.
him. Now your lordship coming to future conduct. This is one part.
No, future conduct will come later.
Yes.
Now you just tell us that this particular document, let us finish on this registered document.
Yes.
There is a presumption under section 16 which talks about past transaction. Section 16.
says if a deed is registered, then validity of the deed cannot be
No,
questioned.
if the deed is registered referring to past transaction of adoption.
Yes.
Can you read it once?
Yes. And it's a presumption of registered document relating to adoption. Whenever any document registered under law for the time being in force is produced before in court purporting to record an adoption made and signed by the parties giving and party taking in adoption, the court shall presume that adoption has been made in compliance of the provisions of the
That's
Act. Yes, unless otherwise proved. Now your lordship I'll show your lordship the otherwise. First, in the registered deed, otherwise had he not disclosed his age as 14 years, it would not have been registered because registering authority will make a inquiry to that effect. One. Two, your lordship will take into consideration whether there was actually an adoption or not. Section 12 of the Adoption Act says that the boy who is given in adoption will sever all ties with his ex-family. He continued mentioning his biological mother as his mother.
Did he
Just-
fill up his class 10 examination form prior to his?
He has not. It is his defense taken, not proved. One. Two, your lordships, intermediate. He cannot say that I filled up intermediate prior to doing matriculation. So if there is a change of name, he has to give an affidavit that yes, I have been given in adoption.
What was his age at the time of intermediate?
Lordships, his age in 89 was 18, more than 18 years, 19 years.
89.
87, 69 is the date of birth. 87, 18 years. And
So
graduation.
even at the time of class 12,
Yes.
he had not yet attained majority.
Yes. As per.
Correct?
Yes. 89, graduation.
That's right.
He has given.
89, he disclosed his age, his declaration in 89.
Yes.
Right? He filed his application in 1989 only.
Yes.
Right?
Yes. He in 89 educational certificate also he gives the name of his biological parent after entering into the employment. He discloses his biological mother's name as mother in the list of dependents. Only list of as a father he had to mention the adoptive father's name, but while mentioning mother's name, he disclosed the name of his brother as his own brother. Also, they cannot be continued as a dependent. I have severed all the relationship with my original family. Those things were seen, and lordship, there is a finding to that effect. If the lordship sees the inquiry report, Lordship will kindly come to page 141. 3 findings given. 1. Age more than 15 years, not eligible to be given in adoption. 2. Educational certificates of the year 1989, 1987, 1989, 1993. Lordship, page
Which is
140.
1993 certificate?
Lordship, that they have not brought. He is saying orally what he has submitted is a school living certificate. He says.
You tell us.
So entire records have not been produced. That certificate has not.
That is your problem. We do not.
Lordship,
You are
one
making
thing.
an allegation with regard to
Lordship, there is
1993.
a finding in the inquiry report.
That 1993 certificate is what? Graduation certificate? No.
There has to. He has not said that there is no certificate of the year 1993. Then the perversity.
You tell us from the inquiry report.
Yes, inquiry report says 3 things. First, Lordship, will kindly come to page 141.
141.
Yes. Lordship, will kindly come to the 4th paragraph. I'll give one by one, Lordship, the 3 findings. 4th paragraph, it is established that deed of adoption was executed on 25/1/85 and accordingly in view of his age recorded in the service sheet of Suresh Kumar Singh and also accepted by him, that is 5/12/69, he had crossed the age of 15 years required for legal adoption. 1. Next paragraph. 2. That after adoption, the adoptee severs his relationship with biological parents for all purposes, but there are evidences which indicate that educational certificates of Shri Suresh Kumar Singh pertaining to 1987, 1989, 1993 after the adoption bears the name of biological father Ram Lakhan Singh, and that is he continues to have relationship with the original family.
So there are okay, these 3 documents are after the adoption.
Adoption.
Class 10 is 85,
85.
prior to adoption.
Thereafter, Lordship, may kindly see. Lordship, may skip one paragraph. The big that is inquiry held on 19 sittings as well. Lordship got. That is the 3rd finding. Inquiry was held in 19 sittings. Suresh Kumar Singh fully participated in the inquiry through his co-worker and availed all reasonable opportunity provided to him to defend the charges leveled against him. He had availed, Lordship, may kindly mark the 3rd finding. He has availed LTC benefits by declaring Rameshwar Singh as father and Srimati Devbrat Devi as mother. Though he was son of Ram Lakhan Singh, he had crossed the age limit at the time of adoption. The adoption was invalid. Srimati Devbrat Devi is wife of Ram Lakhan Singh. Lordship, may kindly mark. Wife of Rameshwar Singh has already died. That is mentioned in the deed itself. And the biological mother of Suresh Kumar Singh, but he declared as wife of Rameshwar Singh. That means he had not severed ties. He wanted to extend the benefits of his service to his biological parents.
So you could have denied any such benefit being extended to biological parents, but you will question the adoption itself.
Lordship, one thing, if there is a valid adoption, then Lordship, he will not keep any tie. If he is keeping tie, that means there is not that adoption is a
They are
pseudo
belonging
adoption.
to the same family. His status quo, those persons would be what? Nephew.
Lordship, then
You just think. You see, there are 2 full brothers of the same family, right? One son goes in adoption to another. How will he sever all ties with him?
Lordship, he will not extend the benefit. Lordship, I will come to it.
It is one thing to say that you reject the benefit extended to them.
Lordship, this is a very small thing. Reject the benefit. If a person is either he is trying to play fraud, even then he is not entitled to.
He has not played any fraud with
Lordship,
you.
if
You have given him appointment with your
Lordship,
open
take into
eyes.
consideration adoption. This part, Lordship is saying that it was very easy. That you could have rejected that benefit. Lordship, if a person in service, Lordship tries to extend the benefit of his own son,
It
LTC
is not
benefits
your
they give in a wrong
case.
age.
You see, it is not your case that charge sheet also does not say that he has fraudulently taken appointment, right? The person who had adopted him, he himself had applied for his appointment and given his name, isn't it?
Lordship, the process is that where a person in service applies for his retirement, premature retirement,
That's
because he is unable to. He will be medically examined. He will be severed. Once he is severed, one of his dependent can apply for employment.
As per NCWA,
NCWA.
right?
So he
One of
applied
his
for-
dependent only.
Yes.
Then
So
he must have
applied as a
given.
dependent.
He must have given the name of his dependent,
Yes.
the
And
ex-employee.
thereafter the son applied. The
Firstly,
petitioner
that
applied.
firstly at the time of this medical examination
suppose I-
and
lots of
claiming
that-
that benefit under NCWA, the ex-employee only gives a declaration as to who would be taking the appointment.
It is not necessary. If I have no dependent, still if I am medically invalid, Lordship, I will be prematurely retired if I make an application. He was declared medically unfit. He was made to retire. And
So
Lordship,
any person who is declared medically unfit, irrespective of any sponsorship by him, any of his dependent person can come and seek employment.
Lordship,
That
naturally
is not the scheme of
consent of the employee has to be taken.
Has to be taken, no?
Yes.
So he is the person who is sponsoring him as his adopted
sponsored,
son.
yes. That is I say.
Yes.
That this everything has been done only to secure the employment for himself. Also, everything has been done only to secure employment.
So what's the illegality about it?
Illegality is that adoption was only for the
You see,
purpose of-
whenever a person is to be adopted, right? He knows that can also be a consideration at times, that the parties are thinking that yes, such and such a person in the family has lot of property. So instead of entering into other kind of legal jargon and legal problems, I will give one of my child as adoption to the other person, and then the property will automatically devolve accordingly.
Also, this is
There is no harm in having. This is something which is very commonly happening in society.
commonly happening, but this is we say it is, and the finding is it is a sham transaction. Sham
This
transaction.
deed
because-
was there with you, no?
Her deed was there.
You have seen it. You have read it.
Yes.
What sham transaction are you
Lordship,
talking
these things
about?
were not noticed. When a complaint
So
came, we
who
met
is
for
going to bear
Lordship,
this?
one thing, when the complaint came, further inquiry was done and further facts revealed. Lordship, deed was with us. Now, post appointment, other educational certificates, Lordship, that was verified. We called for the certificates, he submitted it, we verified it. We were not showed away only by the age. We called for the documents. Lordship, if I was given in adoption and I fill up the intermediate form thereafter, Lordship, I'll give my adopted father's age. At best, they may raise a query that how can you change your father's name?
That's the moment you give the name of your adopted father, your application will not be accepted.
No,
for 12th and
it has to
further
be supplied by
education.
Lordship, it has to be supported by an affidavit along with the deed that I have been taken in adoption. Lordship, there is change of name of candidates also. In the matriculation,
You
one
see,
name.
once the adoption is complete,
Hmm.
let us assume a situation that an adoption is complete, and then adoptive parents, they take the child also, and they act also as per the adoptive parents should, and subsequently the child continues to write the name of his biological father. What is the consequence? The adoption will get nullified by subsequent conduct.
Lordship, the adoption.
Does the adoption gets nullified by a subsequent conduct of the child?
No, but there is no
For
adoption.
that, there has to be a cancellation deed.
Lordship, suppose an adoption deed has been created for a particular purpose.
That is another thing, Mr. Das.
No,
Suppose
this
there
the
is
fact
an.
here. Lordship, the deed has been brought onto existence only, your Lordships, to secure employment.
That is not your.
That is our case from the very beginning. That it is a pseudo adoption deed. Kindly see the chart sheet also.
See
You
the
did
chart
not sever your ties with the family. You continued and you continued. This is the chart sheet. That even subsequently you continued.
That is why I am saying if a person does not sever
Hmm.
the relationship with his biological parents,
Then there is no adoption under the Hindu Adoption Act because Section 12.
the ceremony is conducted, right? Adoption is complete in all respect, and after some time the child continues to use the name of his biological father.
Also,
What
once the
will happen
ceremony
to
is
the-
conducted, if you Lordship see Section 12 for a moment. Section 12 says effect of adoption. The adopted child shall be deemed to be the child of his or her adoptive father or mother for all purposes with effect from the date of adoption, and from such date all the ties of the child in the family of his or her birth shall be deemed to have severed and replaced by those created by the adoptive family. So Lordship, he cannot declare,
And further, provided that
provided that the child cannot marry a person whom he or she could not have married if he or she continues. The property which vested in the adopted son before adoption shall continue to vest in the child. Third is, adopted child shall not divest any person of any state which vested in him before the adoption. If before the adoption something vested, any right created, that will continue.
Section 15.
Valid adoption not to be cancelled. No adoption shall be which has been validly made can be cancelled by the adoptive father or mother. Because once I give in adoption, I cannot cancel and say that give back my son or any other person. Nor the adopted son can renounce his or her status as such and return to the family of her.
So his renunciation of his status as showing his adoptive father as father is incorrect. But that does not mean that his adoption is incorrect and his employment is incorrect.
Lordships, our argument is that he has, Lordships.
You have heard it.
Yes. Now, Lordship, in one
That's
case, I've given the judgment of this honorable court. Gopiram, the brother, the nephew took employment, declaring himself to be the brother of the employee. The brother took employment, declaring himself to be the son of the employee. Own blood. Same is the relation here. Lordship says that brother, Lordship, when it was proved he was terminated, his dismissal was upheld by this honorable.
Is it a case of?
That is a case of
That's a case of fraud.
impersonation and fraud.
Here also it is a
Impersonation?
case of fraud.
No.
Lordship declaring
fact.
his adopted or biological mother as his adoptive
We
mother.
consider your argument.
Yes.
Give me that judgment also.
I have given the copy, Lordship.
You have
All the
given it
judgments.
along with your written submission.
Yes. And secondly, Lordship will take into consideration.
We will. We'll take
Section.
into consideration everything. You
Yes.
see, you just can't annex the judgments like this. If you don't place it, I will not consider it. You have placed this judgment, I will record it.
Lordship, I'll place all the judgments then.
You place all the judgments.
Yes.
With paragraph number specific.
Yes.
We have also given the judgments with our written synopsis.
एक और होगा ना ऐसा written submission एक petitioner का respondent को. You just refer to your judgment in response. First, let him finish. So this is one judgment you are referring to.
Yes.
LPA number 719. This is dated Okay, which paragraph of this judgment you are referring to? LPA?
LPA Gopiram.
Which paragraph?
Lordship, kindly come to the facts of the case at paragraph 3.
Yes,
May I read
you
out?
just come to the findings strictly.
Should I come to the finding directly?
Yes.
Para 7, the learned single judge has recorded a finding that it is not a case in which penalty has been order has been passed ignoring the relevant material on record. The contention raised on behalf of the petitioner that in view of the unblemished service record for long period penalty of dismissal from service was disproportionate to the charges framed against him has been rejected by the learned single judge primarily on the ground that misrepresentation itself amounts to fraud. In Dev Kumar versus State of Uttaranchal in 2013, Volume 9, SCC 363, the Honorable Supreme Court has held dishonesty should be permitted
Para
to be
7 and 8. right?
In fact, Lordship, facts para 6 also, if your Lordship permits me, my submissions are there. Mr. A.K. Das, learned counsel appearing for the respondent CCL has contended that Srimati Bhukani Bai, wife of late Dukalu BP, was herself employed in CCL and she had opted for VRS under which her son was appointed, and thus even the real son of the deceased employee could not have been offered a compassionate appointment. The decision of Muhammad Jamil Ahmad clearly distinguishable on the facts in as much as the said case the brother of the deceased employee was given appointment on the undertaking that he would support the widow and the minor children of the deceased employee. Supreme Court found that the appointee did not make any false declaration nor did he suppress any material fact for securing appointment. As noticed above, the petitioner, who was not entitled to claim compassionate appointment, had suppressed material facts and secured appointment by impersonating himself as son of the deceased employee. No doubt, under clause 9.3.2 of National Coal Wage Agreement Roman 5, younger brother of the deceased employee, residing with him and almost wholly dependent on the earnings of the deceased employee, may be considered to be a dependent and may be appointed on compassionate ground. However, the fact remains that at the time of death of the deceased employee, late Dukalu BP, another member of the family, was not entitled for compassionate
Yes, we have
appointment.
seen this. Yes.
Now, Your Lordship, may kindly come to 2020 Volume 3 SCC, page 423.
Para number?
Para 12 onwards, may I read out?
You just give us the specific paragraph, don't say para 12 onwards. Which
12
paragraph?
and 12, 13
12, 13.
and 15. That in State Bank of Lordship, because I am reading para 12 because I am not, I need not refer to the other judgment.
This is the scope of judicial review.
Judicial.
That's it. Scope of judicial.
Now, Your Lordship, may kindly come to
Then next,
2004.
2004 volume 2.
Yes. Volume 2 SCC. Just page 105, para 16. Refer to para 16, 17 and 19. 3 paragraphs.
Just a minute. 2004 volume 2 SCC 105 para
16, 17 and 19.
17, 19. Which is on which point?
Lordship, on the ground that if the employment there the employment was
What is
obtained on the basis of a forged, sorry, on the basis not of forged, on the basis of certificate which was wrongly obtained.
False certificate.
False certificate.
False certificate.
Yes.
Different case.
That's right.
The Honorable Supreme Court said that in such cases, even an employee is not entitled for protection under Article
That's
311. And secondly, Lordship, para 19 is important, that where a person has, in that case, the employee had served for 27 years. So, Honorable Supreme Court said that long tenure of service is irrelevant in such cases. He cannot claim any benefit of such long tenure of service.
In case of fraud, long tenure is irrelevant.
Irrelevant. May I read out this?
No, I have understood the point. This has been cited number of times.
Yes.
Next
Lordship, then Your
judgment.
Lordship, Janki versus Central Coalfields Limited.
LPA number
332 of 2020.
332 of 2020. Decided on 24/2/2022. Yes, which paragraph are you referring?
Lordship, kindly come to paragraph 12. It will be at page 18, Your Lordships, of the judgment.
Case of impersonation.
Yes. He wrongly claimed to be a relative. Twelve, 13 and 14.
12, 13, 14. Okay, next.
And also on similar lines,
That's all.
there's one more judgment is there. I'm just one is 2013 bottom 9 SEC, page 363.
On what point?
Also same.
Scope of judicial review.
What will be it has considered both this scope of judicial review and secondly appointment secured by misrepresenting the facts.
2013.
Volume 9 SEC, page 363. Paragraph 12, 13, 14 and 16, 15 and 16. Which I am giving.
This is appointment by fraud.
Appointment misrepresentation at the time of appointment.
And scope of judicial review.
Yes. May I hand over the copy? These are. And also one more thing, if your lordship says whether the charge constitute and misconduct or not, that was an issue raised in the writ application as well as two issues were decided by the Honorable Court. First, your lordship, this Honorable Court said that is in the order, the orders passed by this Honorable Court, your lordship, annexed by the petitioner as Annexure 8 and Annexure 9. Two things he took to please, your lordship, technical please. One, your lordships, the disciplinary authority was not competent to issue the charge sheet or take.
That point we have not raised here
Yes.
since
No,
that
I'm
has
just
been-
pointing out that
Those
issue has been
points are not
decided.
here.
And
I
second,
will
lordship,
record
the
your
charge does
submissions
not-
here and now, so
and
there
the
is no scope of saying
imputation- no,
taking
as-
additional points.
No. And secondly, lordship, the imputation of charge do not constitute a misconduct. They argue. So it says that it constitutes a misconduct. Now, whether it is true or correct has to be seen in the inquiry.
Those points here, no, he is not arguing those points.
No, I am saying it for the reason, your lordship. If your lordship is that imputation of charge do not constitute any misconduct, lordship, that issue was.
Have you argued such a point?
I'm just pointing out as a counsel, lordship. That has been pleaded in the writ application, therefore I'm.
No, on that.
At that stage when the
No, in the present it
It
also
was
he
not-
has pleaded it.
Pleading is there. Before referring to the judgments, I will refer to section 31 of the specific relief act, because the question is of a registered adoption deed. Section 31 of the specific relief act says about cancellation of instrument.
you see, you cannot raise a new plea in rejoinder. Why didn't you argue it at
No,
the
this
threshold?
is our plea on adoption deed. That whenever an instrument or document is standing against a person, he has to get a declaration from a court and say on the point that the adoption deed is a registered document till it is rescinded by a competent court of law in a proper.
If it is null and void.
Then also a declaration is required, and it cannot be said to be void. It cannot be said to be void. Then also a declaration is required.
Is it mentioned in section 31?
But
And
31,
if it is null and void, then also a
31
declaration is
says,
to be required.
yes, void was is there.
Void.
Any person against whom a written instrument is void or voidable, both the things are there, and who has reasonable apprehension that such instrument, if left outstanding, may cause him serious
You see,
injury.
that document of adoption is not against them. It is between your family members.
Yes. So no one has challenged it.
No one has challenged it.
Till it is there, they cannot say it was there at the time of appointment. No one has challenged. That is our case. This was one provision which I was referring, and then they are under Limitation Act, Article 59, 3 years limitation is there to challenge such a document, such a void or voidable document. So that period has also expired. And since the judgment, one is which we have given, 1995. SCC volume 1, it is there with our list of date, page 198. 1995 SCC volume 1, page 198.
Para number?
Paragraph 2. I'm just
What
reading.
is it on?
It is on the validity of a registered deed, and the until it is challenged or until it is rescinded or cancelled in a appropriately framed and before a competent court of law.
Then?
May I read it?
No, you just tell us. Other
Yes.
judgment.
This is there with my compilation. And then one is the Jamil Ahmad's case, 2016 volume 12 SCC 342. I will just tender a copy because mistake crept in. We have given the SCC criminal instead of this in the compilation. Jamil Ahmad. I will read just one paragraph. Paragraph 15. This is 16 volume 12 SCC page 342. And paragraph 14 and 15. I'm just reading two paragraphs. In our considered view, the aforesaid facts would clearly show that it was a conscious decision taken by the state for giving an appointment to the appellant for the benefit of the family members of deceased who were facing financial hardship due to sudden demise of their bread earner. The appellant, being the only close relative of the deceased, could be given the appointment in the circumstances prevailing in the family. In our view, it was a right decision taken by the state as a welfare to help the family, the deceased at the time of need of family. Then 15. In these circumstances, we are of the view that there was no justification on the part of the state to wake up after the lapse of 15 years and terminate the services of the appellant on such ground. In any case, we are of the view that whether it was a conscious decision of the state to give appointment to the appellant, as we have held above, or a case of mistake on the part of the state in giving appointment, or a case of mistake on the part of the state in giving appointment to the appellant, which now as per the state was contrary to the policy as held by the learned single judge, the state by their own conduct having condoned their lapse due to passage of time of 15 years, it was too late on the part of the state to have raised such ground for cancelling the appellant's appointment and terminating his services. It was more so because the appellant was not responsible for making any false declaration, nor he suppressed any material fact for securing the appointment. It was more so because the appellant was not responsible for making any false declaration, nor he suppressed any material fact for securing them.
That's all.
Therefore, and just quickly refer to the other judgments which I have referred. One is 1998, volume 8 SCC, page 59. It is there with my compilation on the point of cancelling one appointment after 9 years. Paragraph 6 is relevant.
1998.
Volume 8 SCC, page 59. Para number 6 at page 64. Para 6 at page 54. In that case, the employees have worked for 9 years, and that was a consideration. That when their initial appointment was found to be invalid, but they were given the protection and they were not removed. And another is 93 supplementary 2 SCC, supplementary volume 2 SCC, page 611. Relevant para is 23. And here the Honorable Apex Court held that it is unreasonable to quash an appointment after 10 years. And one judgment which still holds 1977, we have given with the compilation, 77 volume 3 SCC, page 576, paragraph 4.
576.
Yes. There the appointment was cancelled after several years, and there the Honorable Apex Court said that it is not proper to invalidate appointment after lapse of several years.
The same point you are
Yeah,
referring
yes,
to.
on the same point.
So why do you need to cite? You choose one of them. You choose. You see, there are 4 judgments you have cited, right?
I think 16
One is
will-
after 9 years, other is after 10 years.
16 will suffice.
16 will suffice?
77 is one of the parent judgment.
Okay.
It gives the logic, and then 16 will suffice. And on the point of adoption, I have referred to 1995 SCC,
That's
Volume 1, 198.
for the learned counsel opinion.
And only one thing in reply to the judgment cited by them, none of the judgments are applicable in this case because LPA 719 and LPA 332, these are on point of impersonation. It is not a case of impersonation. Impersonation amounts to fraud because there is a suppression. And so far as 2004 Volume 2 SCC is concerned, that is on a false certificate was tendered. And so that is also a fraud. Fraud vitiates every solution. And the other one, 2039 SCC, Devendra, it was also a case of misrepresentation. And the other was on point of judicial review, which is up to this Honorable Court.
Now you please sit down and do not disturb me at all. Okay? Both of you please don't disturb me. While I dictate, you can tell anything, whatever you have to say after the order is dictated. Heard the learned counsel appearing on behalf of the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that primarily the petitioner is aggrieved by the order of dismissal dated 18/12/2022 within bracket annexure 16/1, and also the order of dismissal of appeal by the appellate authority as contained in annexure 16/1 dated 18/12/2022, and also the order of dismissal passed by the disciplinary authority dated 12/4/2022 within bracket annexure 14. While giving the foundational facts, the learned counsel submits that the petitioner he submits that while the petitioner was 14 years of age, the petitioner was adopted by Rameshwar Singh, though his biological father was the full brother of Rameshwar Singh. The deed of adoption was registered subsequently on 25/1/1985, and the adoptive father, namely Rameshwar Singh, declared the petitioner as his dependent in his service excerpts also. Sometimes in the year 1988, Rameshwar Singh applied for voluntary retirement on account of medical unfitness, and as per the provisions of NCWA, the petitioner was offered employment the petitioner had taken his class 10th examination in the year 1985, and whose all formalities were completed prior to adoption, and he had declared, wherein he had declared the name of his biological father. The application for the appointment of the petitioner in terms of NCWA on account of voluntary retirement of Rameshwar Singh on medical ground was filed by the petitioner on 3/5/1989, and ultimately the petitioner was granted the appointment, and by this time he had attained the age of 18 years. He has also submitted that the petitioner passed class 10th examination in the year 1985, class 12th examination in the year 1987, and passed his Bachelor's of Arts in the year 1989. In the year 1993, he was issued the college leaving certificate. As per his class 10 certificate, the date of birth of the petitioner is, give me his date of birth,
5/12/1969.
5/12/1969. The learned counsel submits that the petitioner continued to work and on 9/6/2016, the petitioner was issued a show cause as contained in Annexure 4. To which the petitioner responded, and ultimately charge sheet dated 1/2 2nd February 2017 as contained in Annexure 5 was issued to the petitioner, wherein two allegations were made. A, the deed of adoption was signed on 25/1/1985, and on this day the petitioner had already crossed the age of 15 years, and consequently the adoption was void in terms of clause 10 within bracket Roman 4 of the Adoption Act of 1956. And secondly, the educational certificates obtained by the petitioner in the year 1987, 1989 and 1993 after the adoption bears the name of the biological father of the petitioner, namely Ram Lakhan Singh. With this allegation, it was alleged that the available records established that the petitioner had cheated the respondent and managed to get employment in CCL through invalid and pseudo adoption deed. The petitioner responded to the same by the Annexure 6 dated 9/2/2017 and denied the charges. The learned counsel has specifically referred to section 16. The learned counsel has referred to the show cause reply and has submitted that section 16 of the Hindu Adoption and Maintenance Act 1956 was specifically referred, which deals with the presumption as to registration of documents relating to adoption. He has also submitted that the reason for maintaining the name of biological father in the certificates of educational qualification has been given in internal page 6 of the show cause reply by stating that the petitioner was registered for appearing before the date of adoption, and as such in his name appeared, the name of biological father appeared in his certificates. The learned counsel has submitted that the inquiry report was submitted. The findings of the inquiry report is from running page 141 of the writ record. The Learned Counsel has submitted that the arguments of the petitioner was not accepted by the inquiry officer, and the inquiry officer recorded a finding that the petitioner, though that the petitioner continued to maintain dual identity as son of his biological father also. The authorities have recorded that any adoption made in contravention of the provision of Hindu Adoption and Maintenance Act is void. And that the petitioner could not prove any custom or usage applicable to him which permitted adoption beyond 15 years of age. The Learned Counsel submits that a second show cause was issued to the petitioner, and ultimately the disciplinary authority passed the impugned order of dismissal The Learned Counsel submits that the disciplinary authority also recorded that the appointment file could not be placed during the inquiry as the same had been missing. And this itself created reasonable doubt to a prudent mind, which led to irresistible inference that the file was misplaced due to misplaced capriciously to conceal the irregularity. The Learned Counsel has submitted that there was no such charge against the petitioner. The Learned Counsel has further submitted that the petitioner filed appeal, and the appeal was also dismissed. And was also dismissed by referring to some legal opinion. Inter alia, by referring to some legal opinion wherein it was opined that the deed of adoption does not create any valid adoption, firstly for the reason that the petitioner could not have been taken adoption on 25/1/1985 as he had already crossed the age of 15 years on that day. Secondly, as per his own showing, even after several years, the petitioner continued declaring his biological father as his father in all the documents and education certificates, which were in fact obtained in subsequent years, that is 1987, 1989 and 1993. The Learned Counsel has submitted that both the impugned orders are ex speciae perverse, inasmuch as the deed of registration of adoption is not the date of adoption. The date of adoption was preceded by the date of registration. He has further submitted that the continuation of the name of biological father in the education certificate was well explained. The Learned Counsel has also submitted that there is no allegation of misrepresentation or fraud on the part of the petitioner. The document on the basis of which the petitioner was taken into employment is the adoption deed. The petitioner had worked for long years, 32 years.
Yes.
32 years before he was
More than 32 years.
more than 32 years before he was dismissed from service. The Learned Counsel has relied upon the judgments passed by the Honorable Supreme Court reported in. The Learned Counsel has also referred to Section 31 of the Specific Relief Act, which deals with cancellation of instruments. He submits that no steps were taken for cancellation of the adoption deed. The adoption deed continues to be legally valid and enforceable. He has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 1995 1 SSC 198 para 2 to impress upon the validity of the registry of the deed. He has further referred to the judgment reported in bracket 2016 bracket close 12 SCC 342 to submit that there is no justification to wake up after long years to make an allegation which is not based on any suppression, misrepresentation or fraud on the part of the petitioner. The Learned Counsel has also submitted that when the adoptive father himself has disclosed that the petitioner was duly adopted by him, there was no question of questioning or challenging the adoption deed itself. The Learned Counsel, appearing on behalf of the respondents, on the other hand, while opposing the prayer, has submitted that the petitioner had cheated and managed to get appointment based on invalid and pseudo adoption deed. Since the petitioner was more than 15 years on the date of execution of the adoption deed, the same itself is void ab initio and could not have been relied and cannot be relied upon by the petitioner. The Learned Counsel has placed the adoption deed to submit that the adoption was made for the purposes of seeking employment with the respondents. He has also submitted that in the registered deed, the age of the petitioner has been mentioned as 14 years, which is also incorrect if the age of the petitioner with respect to his class 10 certificate is taken into consideration. The Learned Counsel has relied upon judgment passed in LPA number 719 of 2015, Gopiram versus CCL, decided on 20th September 2016, reported in 2016 SCC Online JHAR 2695 para 7 and 8. And has submitted that the employment secured through fraud is vitiated. He has further relied upon judgment reported in bracket 2020 bracket close 3 SCC 423 para 12, 13 and 15 to submit that the scope of judicial review is very limited. There is no scope for reconsidering the materials on record and coming to a different finding once there are concurrent findings and findings recorded by two authorities. He has also relied upon the judgment reported in bracket 2004 bracket close 2 SCC 105 para 16, 17 and 19 to submit that long tenure of service is irrelevant, and in the said case there was 27 years of service. He has submitted that in case of giving false certificate, there is no protection of Article 311 of the Constitution of India. The Learned Counsel has relied upon the judgment reported in LPA number 332 of 2020, para 12, 13 and 14 to submit that in case of fraud, misrepresentation / impersonation, no relief can be given to the employee. He has also relied upon the judgment reported in bracket 2013 bracket close 9 SCC 363 para 12 to 16 to submit that that the said judgment deals with the appointment obtained by misrepresentation and also the scope of judicial review. Arguments concluded? Anything left?
No.
Anything left from your part?
One plea we have taken about another employee who also moved earlier now.
We are not concerned with
No,
another.
that was in reply to the charge sheet and inquiry report.
So
That reply
things
was
which you have not argued, please don't argue after the dictation of the judgment of the order. We have a this holy break in between, right? I am posting this case for judgment on April 8th. This other side has come in your case.
That.
Mentioned
This is one order recent, which referred both the LPS.
Item 55. Item 55 along with item 56 to 58.
43, 44 and 47. 43, 44, 47, 55.
Just a minute. 43,
44,
44,
47,
47,
55,
55,
56,
56,
57,
57,
and 58.
58. In all these cases, counter affidavit filed? Not filed.
No, serial 55
No problem.
counter affidavit is ready, but it will not be filed.
Now in all these cases, I have also passed an order, right? We have given the foundational fact also in all the cases which I have disposed of. But these cases will also be disposed of in terms of the directions issued by the Honorable Division Bench in both the cases, right? Which is that case, Saurav? Which is that case? You have that case number? Give me the case number, please.
4936 of
4936 of
2023.
2022.
3.
Over 2023. इसके साथ ना इसका सॉफ्ट कॉपी लगा देंगे और ये केस का ऑर्डर हम लोग फाउंडेशनल फैक्ट इतना ही देना है whether they are para teacher applied under which category.
Lordship, in serial number 43, the facts are slightly different now.
You see, we are not pronouncing anything. The reason is that no counter affidavit is there. It is for them to verify the
As per
facts.
petitioner also, Lordship, what has been mentioned in the writ petition, it is not a case of para non-para. In this matter, there is a dispute that they have got certificate from Hindi Vidyapit, and now, as per the one of the notification, they have.
You see, they are saying that if they are covered by this order, they will be called. If they are not covered by this order, they will not be called. So nothing more we want to say anything about it. Let this counselling be done, isn't it? And it is only one time counselling.
One time.
Simple. If they are called, it's okay. If they are not called, we do not know. We cannot take up individual cases like this because there are so many persons coming up for counselling. Right? Foundational fact we will mention, and that no counter affidavit has been filed. We shall mention that.
In my case, when the counter is ready, so that.
No, you should have filed it 48 hours before. We have disposed of in terms of those two judgments. In this judgment also that we have also disposed of. All these cases. Appearance memo de dijiye.
And with respect to item number 1 of 215 list number, I will be grateful if I was picked up in the coming Monday.
You want adjournment?
Yeah, next week.
Like you file this. Readings complete.
Clearly complete.
So why do you need time to declare?
Item 1.
I only have to bring on record a copy of circular of 2015. Relying upon that circular, they rejected my claim. I just bring that circular on record.
You see, once the pleadings are complete, what do you want? Where is that circular of BAL employment?
Compulsory appointment circular, he's saying that copy is with me now, sir. I have got the
Does it talk about
It is
BAL
only-
police?
No, only compulsory appointment.
Only compassionate appointment. So,
Let it be on Monday. Monday will be
Monday किसने देखा? आपने देखा? I have not seen. परसों रख देते हैं. Give him the circular and give me the circular also. The circular regarding compassionate appointment has been produced by the respondents for consideration, a copy of which has been provided to the council for the petitioner.
Only
Post this case,
29
they
now,
have
sir,
to
29 now, so there is some concern now.
Thursday.
Every time you are not very serious in court.
From
For every date you have some function
only 29
somewhere.
now, sir. I pray not, sir, 29.
Thursday for a
Thursday को दिया है, खाली एक दिन के लिए बोल रहे हैं, sir.
Thursday at 2:50. नहीं, यहाँ के लिए दीजिए. There are two circulars.
91 and 2015.
He is governed by which circular?
91 not, sir.
91. Does it talk about any
Because date of that is
BAL police?
The order of yes, BAL police order of rejection referred about 2015 circular, not 91.
Anyways, you have to satisfy
both
either
the
of them.
cut-off date is same, Lord, sir. Cut-off date is same 5 years, Lord, sir.
5
Limitation
years.
period.
And
That is same in
making
both
an
the
application, here we make application much prior to expiry of 5 years period. That I will
No,
write.
that's right. But still, even after expiry of 5 years, you continued to be minor or you became major?
Minor, Lord,
No,
sir.
I continue
Minor judgment on that
minor
issue, Lord, sir.
and I attained majority in the year 2022. In the meantime, by the order of the IGs, they kept my application pending. That till he attains 12 years, then place the application. By that time, they come out.
On this, there is judgment of my lord also.
What have I done?
Dismissed lordships. Almost 5363 of 2000.
Give me the judgment. 5-3?
63 of 2011 lords. That minor cannot claim for the compensate appointment.
ये ऑर्डर का कॉपी लगा दीजिएगा.
5363.
WPS number 5363 of 2011. The counsel for the respondents has also relied upon a judgment passed by this court in WPS number 5363 of 2011 and submits that the present case is squarely covered. The petitioner, being a minor, is not entitled for compassionate appointment. So, we are posting it on Thursday,
Yes,
second half. Next.
Please state at 4:15 p.m. Item 5. Intelligence 703 of 2022. Along with item 6.
Both the parties are present. Where is the other party? There's no join. Yes, Madam Priyanka, are you there? आप हैं यहाँ पर? थोड़ा अपना हाँ स्टेबल कर लीजिए। राजकुमार जी, आप राजकुमार जी हैं? इनका आवाज नहीं आ रहा। आपका फोन बहुत ज्यादा अनस्टेबल है, उसको स्टेबल करिए। आप लोगों का कोई सुलह का संभावना है? एक बार भेजें आप लोग को, मीडिएशन के लिए भेजें, आना नहीं पड़ेगा, ऑनलाइन भी हो जाता है। आप लोग को एक बार मीडिएशन के लिए भेजें।
जी मैम, सुनाई नहीं दे रहा।
आप लोग को मध्यस्थता के लिए भेजें एक बार, बातचीत आपस में करना चाहते हैं आप लोग?
वो नहीं रखेगा मैम। वो शादी किया है उसने, पता नहीं।
आपको जाने का मन है तो बोलिए, हम भेज देंगे। एक बार कोशिश करके देख सकते हैं आप लोग। आपका तो फोन ही नहीं, आपका शक्ल ही नहीं दिख रहा हमको।
इससे पहले मैंने बहुत बार मेडिसिन होने के बाद मैंने बहुत बार कोशिश किया और मेडिसिन भी मैंने बोले रखने के लिए कि रहो चलो मेरे साथ, लेकिन उन्होंने मैं बार-बार कंटिन्यूअसली डिनाई करते किया कि मैं नहीं रहूँगा।
आप तो आप तो उनको अपने स्टेशन पे नहीं रख सकते हैं ना, क्योंकि आप तो बॉर्डर पे होंगे चाहे कहीं भी होंगे, है ना?
मैडम यहाँ पे फैमिली क्वार्टर अवेलेबल नहीं है मैम।
हाँ, तो
फैमिली स्टेशन नहीं है मैम।
आप इनको कहाँ रखना चाहते हैं?
मैम अपना घर में, क्योंकि मैम मैं अपना मदर फादर का अकेला लौता लड़का हूँ मैम।
नहीं मैम, ये आदमी कितना जगह शादी किया है मैम, ये हमको कैसे रखेगा?
अच्छा ठीक,
मैम ये गलत बात है मैम।
अच्छा ठीक, कोई बात नहीं, नहीं भेजेंगे आप लोग को, तैयार नहीं है आप लोग को नहीं भेजेंगे। आप लोग का केस मेरिट पे डिसाइड करेंगे, ठीक है? Criminal revision number 703 of 2022 with criminal revision number 685 of 2023. The parties have joined online. It appears that the parties are not ready to go for mediation. The matter has to be decided on merits. Thursday को रखते हैं? Post on Thursday.
Next week.
Next week, okay. बताइए कौन सा दिन?
Wednesday next.
Thursday criminal revision day है. 7th for final disposal. इसमें रिकॉर्ड आया है? जरूरत है? Yes, madam.
The petition which was filed before the learned family court, it has to be seen.
Yes.
It may be called for.
Both are arising out of the same
same
proceedings. Office is directed to call for the records from the concerned court. This is for final disposal.
No, it is under admission, right?
Let this matter be posted for final disposal on 21st March 24. Let this order be communicated through fax.
Item 2, WPS 3969 of 2023.
Yes, petitioner.
Sir, in this matter, petitioner has paid for appointment in the post of Jharkhand sweeper. Earlier on, the appointment was issued by the respondent for the various posts, and the petitioner was applied for the post of Jharkhand, and subsequently physical test and written examination were held, and finally on 6/4/2016, it was directed to join the post on Jharkhand.
Where is that order?
The order was not issued, madam. Written order was not issued, madam.
Your result was declared?
Similar situated one person also.
We want to know whether your result was declared.
Yes, yes, ma'am.
Where is your declaration?
Annexure 2, page 15.
Serial number?
Last paragraph, my roll number was 15165, serial number 32 in ST category. Anusuchit Janjati. Last paragraph. Yes.
Last page.
Second last, Anusuchit Janjati, Koti Anusuchit Janjati, 32, serial 32. In page
6087.
15165 in page 15.
This is your,
Yes,
you are from SC, ST?
yes, madam. And
SC or ST?
ST.
ST. Your roll number was?
15165. Can we have a look?
1516. Then what happened?
Then on 6/4/2016, I joined on post of Jharkhand and discharging the duty in Bokaro, SISF CAT for Bokaro. Subsequently, on 23/6/2016, one notification was issued by the respondent below, and all appointment was cancelled on the ground that some irregularity was done by some candidate below. On that ground, this all appointment was cancelled.
What is the date of decision?
23/6/2016.
Okay. Then this has been set aside.
Yes, sir. In WPS number 3976 of 2016, the same was set aside.
All right. But you have not been reinstated.
I have not any party on that case. I was not a party on that. On that ground only, he was not appointed, reappointed.
Oh, you have not been reappointed only because you were not a party in that proceedings.
I was not party on that case. And similar situation, one person also not appointed because he was also not party. And later on, he has filed.
The cancellation of appointment was set aside only qua those persons who had come to the court.
Yes, sir. And one similar situated person, namely Sujit Kumar, was also not filed writ petition, who was not party on that writ petition. And later on, he was filed petition, and he was joined, after getting order from this honorable court.
Where is that order?
Annexures 1 of my reply. I filed on 16/2/2024.
This is 18/8/22 order.
Yes, ma'am. May I read?
Just a moment. So his case was to be considered.
Yes,
What
ma'am.
happened thereafter?
He has joined now.
From where do you say he has joined? You have mentioned it. We'll also pass similar order. They will consider your case because you have not disclosed whether he has joined or not.
He has joined, the same
That should be
as
sufficient.
same candidate who has been appointed, in
Just a
paragraph
moment.
6,
Just a moment. Yes.
In this case, your ladyship, it is not similar as the case of WPS 3976 of 2016 because the petitioner joining was not even accepted by the authority, your ladyship, because in para 10 we have mentioned that because of the during verification of documents and measurement of height and chest of the respective candidates, it has been found that the petitioner's chest was short by 6 centimeter, which is the bare minimum requirement fixed, your ladyship. As we have already
So
annexed-
why did you declare him successful? It was not successful. It was not declared successful.
During verification only, he has been disqualified, Your Ladyship.
No, why?
Annexure C.
What is this document? Annexure 3, Annexure 2. This is not the final result.
This was final result.
This was final.
And they have filed Annexure C, Milord. On that, Milord, the name Sujit Kumar also disqualified, Milord.
And in 2016,
No,
Your
you
Ladyship,
just explain.
the
If you say that he was not finally selected, then what is Annexure 2? His name is appearing in Annexure 2. His roll number is appearing in Annexure 2, isn't it?
Yes, Milord.
31/3/2016. He was finally selected.
And in Annexure D, Your Ladyship,
Don't shift from one point to another. Once you say that he was never selected, or he never qualified ultimately, so why his name is there in Annexure 2? What is your stand with regard to that?
Your Ladyship, in the inquiry committee, it has been seen that some discrepancies happened during the selection process. That's why it has been cancelled later on. The total selection process has been cancelled by the state government, Your Ladyship. And the reason why he has not been selected, Your
So
Ladyship,
that is why it was cancelled, because there were some irregularities. So Annexure 2 he cannot rely upon. This is what you want to say. Because Annexure 2 is the final selection list at the first instance.
the first instance.
And that selection list was cancelled, or the entire selection process was cancelled?
Entire selection process was cancelled by state government. Your
What was the reason?
Your Ladyship, in para 11 only we have specific guidelines to be changed, Your Ladyship. And it was by the JAP and DIG Ranchi that some discrepancies found in the measurement of. In Annexure D also we have.
From where
annexed
do
the
you say
document.
some discrepancy was found in the measurement of his chest? What is the document produced by you? His measurement must have been recorded somewhere. Where is that? Your statement will not be taken as correct. Yes? You say that the candidature of the petitioner was not accepted by appointing authority for discrepancies in chest prior to order passed by this court. Where is the document? It cannot be an oral statement. There has to be a record. Where is that?
Your Ladyship, we have annexed D only for the. Yes, Your Ladyship.
Annexure D is what?
Annexure D, page 22. प्रकाशित विज्ञापन में मानक अर्हता के अनुसार नियुक्ति के समय नापी करने की कमी पाया गया है जो त्रुटिपूर्ण है चित्राओं और के नाम पे Your Ladyship.
And kindly have a look, Milord. Sujit Kumar, just first, Milord. Roll number 2944. He has filed this writ petition, Milord, and which was allowed, Milord. और उसमें पाया गया मेधा सूचित प्रकाशित विज्ञापन में मानक अर्हता के अनुसार नियुक्ति के समय नापी करने पर ऊंचाई 2 सेंटीमीटर एवं सीना 4 सेंटीमीटर का कमी पाया गया जो त्रुटिपूर्ण है.
He has not been actually granted. He has been taken in service.
Milord, both have on
Counsel for the
basis of-
parties are present. The counsel for the petitioner submits that the case of the petitioner is identically placed as that of Sujit Kumar, which is apparent from Annexure C to the counter affidavit. He submits that Sujit Kumar had moved this court in WPS number 518 of 2021, and a direction was issued by this court to consider his case. But he is not aware as to whether Sujit Kumar has ultimately been given the appointment or not. Counsel for the respondents is directed to seek instruction and file a supplementary affidavit as to whether Sujit Kumar has been ultimately given appointment, and as to why the case of the petitioner be not treated at par with that of the case of Sujit Kumar. The fact about the case of Sujit Kumar has been brought on record only through rejoinder. Right? Rejoinder में नया कहानी. Isn't it? You file an affidavit.
When,
1 week?
when they have filed
Relation
not
to
the
2
counter
weeks.
affidavit.
2 weeks in addition.
In 2 weeks you need to verify this.
Just to file. 1 week.
Or one more thing.
Let the supplementary counter affidavit be filed by 6th of March, post on 11th of March under the heading for final disposal. Under the same heading, final disposal में है.
With lordship's land permission, to mention on case of serial number 51. In this matter, lordship,
Want to
writ
withdraw?
of Q warrant has been filed with respect to 5 VCs of Jharkhand University, lordship. Therefore, it may be fixed on any early date, lordship. I am expecting that it will be taken up, but not be taken up therefore.
Counter affidavit filed.
नहीं, उसमें लास्ट डेट में ऑर्डर हुआ था रजिस्ट्रार्स ऑफ 5 यूनिवर्सिटीज आर डायरेक्टेड टू फाइल काउंटर, बट नन ऑफ देम हैव फाइल
So they
काउंटर.
will file their counter affidavit. Q warrant में mistake क्या होगा?
क्यों वारंट सुप्रीम कोर्ट के जजमेंट से कवर्ड केस है हम लोगों का, बिकॉज दे आर नॉट हैविंग रिक्विजिट क्वालिफिकेशन ऑफ प्रोफेसर फॉर 10 years.
They have served their period.
They have never been issued notice.
They have served their period or they have
No,
not
no,
served their period.
still they are continuing. Still they are continuing. Therefore, my prayer before
Where is the respondent?
Counter file.
Counter filed है.
Respondent 3 and 4.
state government has only filed counter affidavit which is formal in nature, and rest of the other contesting respondents have
Who has to file the affidavit?
University is required to file counter.
All the universities.
Registrar of all the
This has
universities.
to come from the Honorable Governor. From the Chancellor's office it has to come.
Chancellor has not been issued notice or not directed to file
He has
counter.
been made party.
Yes, Lord.
So why didn't you get the notice issued to the Honorable Chancellor?
I have requested to the Honorable Court. The Honorable Court was primarily of the view that registrar are directed to file counter affidavit. Thereafter, after considering the counter affidavit of the registrars, subsequent order will be passed. Lordship may kindly peruse the order dated 21st of November 2023.
Who is the petitioner?
Petitioner is the trade union leader, Lordship.
So how is he concerned with professors and chancellors
In
and
this
university?
matter,
It is not a PIL.
In this matter, Lordship, locus has already been decided by the Honorable Court. Lordship may kindly have a look to order dated 30th of October 2023. First point of was raised with respect to locus of petitioner. For filing writ of Q warrant, locus is not required, Lordship. That has already been held by the Honorable Apex Court. I will argue on those points again, if Lordship may permit.
There is no urgency, it will come. Today we could not take up the matter.
Any date we will fix, Lordship.
Every case date will be fixed. There is no case without a date, it will come on its own day.
इस वीक में ही कोई डेट दे दिया जाता है या नेक्स्ट वीक में दे दिया जाता है?
के
अर्जेंसी
अनुसार
है
डेट नहीं
ये
हो
लोग
जाएगा. मेंशन करने का एक टाइम टेबल होता है, 2:15 बजे मेंशन किया जाता है. Wherever you are 2:15, you will mention at any point of time you want
I'm
to.
expecting that it will be taken
If
up.
any date will be fixed and case will be taken up on that day, if you mention it will be taken up.
Yes, Lord.
But date we cannot fix the date.
There are so many respondents, therefore it is not possible for me to take consent from every council, Lordship. Therefore, I am praying before Lordship that
Now
any
you have
date-
taken consent from all the parties?
No.
At the time of rising, there is no system of mentioning, unless heaven is going to fall.
I am just submitting for Lordship that any date may be fixed for early hearing.
It will be fixed. You have not filed any petition for early hearing also.